Hello, my name is Brian Craig, and welcome to this presentation on arbitration clause in consumer contracts. Just to start off, giving a definition of arbitration. What is arbitration? It's a dispute resolution process in which the disputing parties will choose an arbitrator or one or more neutral third parties to make a final and binding decision to resolve the dispute. So that's the dictionary definition. So basically, instead of going to court, the parties will agree to go to a neutral third party called an arbitrator who hears evidence and actually issues a decision. And we see a lot of arbitration clauses in contracts between individuals and businesses for consumers. And courts will generally uphold these clauses, even though these clauses waive the Seventh Amendment right to a jury trial and under some state constitutions as well. Under Title IX of the United States Code, where we find the Federal Arbitration Act, which was passed by Congress in 1925, or more than 100 years ago, makes written arbitration agreements and contracts evidencing a transaction involving commerce valid, irrevocable, and enforceable. So, as a general rule, courts will uphold these arbitration clauses. Just to give an example of a recent case from a federal appeals court from the Seventh Circuit, it was a case against Menards, which is a home improvement store with many stores throughout the Midwest. And in this case, uh, the court upheld the arbitration clause found in the online checkout for the consumer. The court held that the retailer's website provided reasonably conspicuous notice of terms and conditions to which the consumer would be bound. The store's online checkout page was relatively uncluttered. The court found that the arbitration clause provided reasonably conspicuous notice to the consumer, such that the consumer passively assented or agreed to the terms in an enforceable agreement forced under Wisconsin state law when the consumer completed the purchase. By completing that purchase, this arbitration clause was clear, conspicuous, and the court upheld that arbitration clause. However, courts will not always uphold arbitration clauses in every single case. Another example, a case from the U.S. Court of Appeals for the Second Circuit. This was a case brought by a consumer and brought a proposed class action lawsuit or putative class action lawsuit against an electric utility company in New York. And the trial court, the district court, denied the utility company's motion to compel arbitration. And that's usually how these come up. Somebody files a suit, and then the defendant, the company, will file a motion to compel arbitration. Here, the Second Circuit agreed with the trial court, held that this form that the utility company mailed to the consumer several weeks after the consumer signed or agreed to this enrollment contract did not provide inquiry notice to the consumer of the form's arbitration provision. So basically, there was the enrollment agreement, did not have the arbitration clause, and then this form was sent several weeks later. The court said, no, we're not going to uphold that. This arbitration clause provision was not a binding contract on the parties. And the court denied that motion to compel arbitration, and the appeals court agreed with that. Again, facts and circumstances vary, but as a general rule, courts will uphold these arbitration clauses. But you can find some cases where the courts will not uphold the arbitration clause in some circumstances. Now, a lot of people don't like these arbitration clauses, and there have been bills introduced in Congress to amend and repeal the Federal Arbitration Act. There's a bill called the Forced Arbitration Injustice Repeal Act, by the acronym the FAIR Act. And this was a bill that's been introduced several times in several different sessions of Congress by Representative Hank Johnson, a Democrat lawmaker from Georgia, and then also Senator Richard Blumenthal, a Democrat senator from Connecticut. Both of these bills that were introduced in 2023 died committee, didn't pass the committee and receive a floor vote. And generally introduced by Democrat lawmakers and haven't gained enough support. These bills, if passed, would give consumers access to the court system, reject big corporations' use of fine print to deny consumers of a critical legal protection. And these Arbitration clauses, there are arguments in favor of arbitration clauses and arguments against arbitration clauses. And that's the current state of law. Courts will generally uphold these arbitration clauses in consumer contracts. So thanks for listening.